There being 6:30 on July 9th, I'm going to start the zoning board of appeals office. I pledge allegiance to the flag
of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
In accordance with Mass General Law, Chapter 38, Section 20F, this meeting is being recorded. The first hearing is 28 Cahoons Lane, a continued hearing on application of Brandon Lord applicant and Quinton D. Lord and Brendan Lord owners for variance from the frontage requirement as the subject property lacks frontage on a street or way for purposes of maintaining the property as agricultural use as well as constructing a single-family dwelling as mandated by zoning bylaw, Article 7, Section 7.1. Subject property is located at 28 Cahoons Lane, Westport, Mass., and is shown as Assessors Map 2, Lot 13. Voting on this will be Jerry Coutinho, myself, Roger Menard, Ray Elias, Janice Day, and Cynthia Kozekowicz. And first of all, I'm going to start off with what brought this about is a letter from Ralph Souza, the zoning enforcement officer. Dear Mr. Lord, after review of assessor's records for Lot 13, Assessor's Map 2, it has been determined that the lot in question contains 14.25 acres of land but lacks frontage on a street or way as required by the zoning bylaws, Article 7.1, minimum residential lot and frontage. Therefore, the lot in question is considered unbuildable. You may appeal this determination as allowed by Mass General Law, Chapter 48. Okay, the way we'd run the hearing is I'll have the petitioner come up, or the petitioner's representative come up to the table and provide whatever information is pertinent. The board will then ask questions of the petitioner. Once the board has asked all the questions, I'll then open it up to the general public. So will the petitioner come up? Name and address.
Certainly. Good evening, members of the board. My name is Peter Solino. I am a lawyer, and my address is 550 Locust Street in Fall River. I represent the applicant, Brendan Lord, and obviously here tonight to argue the application or petition on his behalf. Start my presentation this evening with what the proposal is. So to the extent you're unfamiliar with the site, the proposal is to erect a single-family dwelling on the currently used, or on the lot that is currently used for agricultural purposes. The property is accessed via a deeded right-of-way, and as noted by Mr. Menard, there is no frontage on Cahoons Lane. Mr. Giosa, who is the engineer on the project, has previously submitted and stamped a letter relative to the title to the property, and so I'd like to start my legal presentation there. I did some research in preparation for the meeting on the town's website, and I'd like to submit into the record March 19, 1957, which was the town's adoption of zoning. If I may pass it to your clerk, I've made sufficient copies, I think, to circulate around. So based on my reading of the attachment, and for the ease of the use of the board, I've highlighted the pertinent sections. I'll wait till it comes around the table so I can call your attention to the necessary sections.
Make a copy for.
I do. Do you have an extra one?
I'm going to
share
read.
for the-
I'm going to read from it,
We'll
but
share for the moment.
I can. Yeah, certainly I can pass this one in. So what's before you is printed from the town's website. This is the enactment of zoning at the March 19th, 1957 town meeting, and I'm calling your attention specifically to Article 36 on the town warrant and subsection 5-B, which I've highlighted. Again, it's towards the bottom of the page. So for the board's understanding, it looks like pursuant to this Article 36, the town of Westport adopted zoning and/or minimum dimensional requirements, which were approved by the Massachusetts Attorney General on April 18th of 1957. And similar to many town bylaws, there was an exception that in pertinent part and highlighted at the bottom of the page reads, foregoing section shall not prohibit the erection of a dwelling in any district upon a vacant lot having less than such minimum requirements as to area, frontage, or width. On to the next page. If the owner of such lot on the effective date of this bylaw owned no adjoining land available for the use in connection with such lot. I think that's a very important component to the argument in the petition before you. As Mr. Giosa's research indicates, this lot should be considered a pre-existing non-conforming lot. The title research indicates that it has existed as a lot in these dimensions since the early 1900s. Moreover, that no abutting property owner has owned this lot in conjunction with a lot that shares a lot line with this lot. So for all of those reasons, I start my presentation to submit to you that I certainly respect Mr. Souza, but I respectfully disagree with his characterization that this is not a buildable lot, because I think it is a lot of record and it is a pre-existing non-conforming lot. But obviously, he disagreed, so now I'll address the variance component of the petition. As the board knows, 48 Section 10 allows the board the authority to grant a zoning variance provided that the applicant or petitioner can demonstrate certain statutory elements. First, we have to be able to demonstrate to you that the soil condition, shape, or topography of the land is unique, and that uniqueness is not generally affecting the zoning district, but rather is unique to this parcel. Next, we have to show you that a literal enforcement of the ordinance or the bylaw would involve a substantial hardship, whether financial or otherwise, to the applicant. Third, we need to show that it is desirable that the relief be granted without detriment to the abutting parcels. And finally, we seek the relief in a manner that will not nullify or derogate from the intention of the bylaw. And so for purposes of my presentation on the variance component of the application, I submit to you the following. First, the site, which is depicted on this easel here, is somewhat of a unique shape. It's a quadrilateral piece of property that has no frontage on the lane. I'd submit to you that that characteristic is certainly not a general characteristic that affects the whole zoning district, but rather is unique to this parcel, which again, based on the title research in the record, indicates that the parcel has existed for many years. Next, I'd submit to you that there is a hardship here. My client is a farmer. The property is currently operated as a farm. He has 7 acres of corn. He has 5 cows. Currently, he lives less than a mile from this site. The house that he lives in is located at 343 Old Bedford Road in Westport. That house is currently for sale, and his end game is to build a house on the parcel before you. So to the extent he can't do that, and let's just say for sake of example, he has to live in Dartmouth instead of Westport, operationally there's a significant hardship to the farm there. Again, animals and crops. Next, I would submit to you on prong 3 that desirable relief could be granted here without substantial detriment to the abutting parcels, and here's why. My understanding is there's opposition, and I'm sure we're going to hear from Mr. Feingold relative to that opposition. And it will come out that there was a prior case involving this parcel in which my client erected structures and operated businesses without permits, and that is a fact. But key to the analysis on whether or not the proposed relief is detrimental is that in that agreement for judgment, which I'm sure Attorney Blake was involved in, it says that my client can crush rock incident to farming. And so when I look at substantial hardships and balancing the equities here, I would suggest to the board that crushing of rock is a much more noxious use than a single-family home, cows, and corn. So I think that you could find it within your power that the proposal is substantially less detrimental than what could otherwise be done there pursuant to the current agreement for judgment. And then finally, certainly you can't grant relief unless it is consistent and does not derogate with the intent of your bylaw. So calling your attention to the intent. Section 1 of your bylaw says that the purpose of the bylaw is A, to encourage the most appropriate use of land, skipping to C, to conserve natural resources, and skipping to H, to encourage housing for all income levels. So addressing those in sequence. I'd submit to you that it is in the best interest of the lane, the neighborhood, and my client that the use of the land be a residential agricultural use consisting of his dwelling and a farm. Next, I think that the proposal would serve to conserve natural resources, inasmuch as you have about 13 acres of land here with one house, and therefore those natural resources, inclusive of livestock, crops, would be maintained. And then finally, when you look at encouraging housing for all income levels, we know farmers don't make a lot of money, but I think this gentleman's entitled to have a house on a pre-existing non-conforming lot. And so for those four arguments, I'd submit to you that we can meet the burden of 40A, Section 10, relative to the grant of a variance if the board can't make a finding that it's a pre-existing non-conforming lot of record. Be happy to answer any questions, as would my client.
Could I ask you?
Certainly.
Just to clarify one piece there about crushing rocks.
Yes.
Is there a specific approval someplace? Is that what we're reading?
As a result of the settlement of the case with the town of Westport, there's an agreement for judgment which is entered in the Superior Court case. And there's an exhibit to that, Jerry, that says, it lays out the things that my client can and cannot do. And it indicates in it that,
Is that document that you're reading from, is that part of the packet that you presented?
no, it's part of the opposition. Okay. It's part of the opposition. It's in a court order. It's subparagraph C. It lays out all the things that Brendan cannot do. And then it says, provided, however, the defendants may use the property for lawful farming activities, including the crushing, removal of rocks and boulders for farming purposes.
So in reality, if we were to approve this, he could still do that.
Certainly, he could, yeah.
Oh, well, they fall into agricultural uses.
Yeah. But the way you were reading it, it appeared as though this would be better than crushing rocks. You could
what-
still crush rocks.
Well, I
He
think
can
you know
still pick
this.
stone and make sure he's got
Yeah.
a stone pile somewhere.
Yeah.
I was presenting an argument on behalf of my client.
Attorney Blake, can you comment on this Article 36?
Sure, and this has to do with the grandfathering. I mean, it does appear that at some point you adopted zoning. I don't know if the lot was, if that particular lot was actually in existence at the time this was adopted.
It is.
Typically, what happens is when you make that kind of argument, you provide us with a memorandum with exhibits, and we're able to go over them. I saw a memorandum, but it really just said that this was never held in common ownership. It didn't walk through and provide us with this document. Moreover, if you look at 40A, Section 6, Paragraph 4, it talks about, and you were right, was not held in common ownership with any adjoining land, right? This is for the grandfathering. Conform to the then existing requirements, and I think that's what you're saying here. Although there's not, this talked about dimensional. I mean, our biggest problem is
Frontage.
no frontage. And had less than the proposed requirement, but at least 5,000 square feet of area, which you guys absolutely have, and 50 feet of frontage. Do you have 50 feet? Do you have?
No, there's no frontage.
But even that strip is a deeded.
It's a right-of-way. So
What
just,
does that mean? I mean, is
It's
it
an easement.
deeded? It's an easement.
yes.
So he does have an easement to use that? and go
Yes.
over that. How wide is that?
Can I pull in Mr. Giosa? 2 points
Mike, or Mike?
in response. Before I was involved in the petition,
Yep.
Steve submitted title research, and then I submitted a supplemental piece of title research because there was one piece he left out. So Steve, can you address the title piece?
Yeah, from the title, for the record, Steve Giosa, SciTech Engineering, office at 966 Kempton Street, New Bedford.
Name?
Stephen Giosa. So yes, when I first started working with Brendan, we did a title search on the property, and we did submit to the town a complete listing of the title information for the subject property going back to the early 1900s, so well before 1957. And then we looked at each of the adjacent properties and traced the title back on those. And we did submit all the book and page references, all the ownership names for each of the adjacent properties, as well as for the subject property. And as Attorney Salino indicated, I did miss in typing one of the parcels that we researched. And so we added that into a supplemental document. And we have looked at all of the adjacent properties. There's been no common ownership going back to the early 1900s, like 1920s, I think we were back to. And we still did not see any common ownership going back that far. So you have an isolated parcel. It existed prior to 57 as an isolated parcel, and in fact, going back to the early 1900s.
That doesn't answer the question of the easement on the,
So there is an existing, if we can look at the other exhibit, and I'll go back to the microphone. And this plan is 1 inch equals 30 feet. So there is an existing gravel access that originates on Cahoon's Lane and leads up to Brendan's property. That's a gravel road, it's variable width. It probably averages around 10 to 12 feet wide. But it's a single access to the farm property as it exists now. It serves that purpose for a farm. And when you look at a typical home, a 9 to 10-foot driveway is not uncommon, 10-foot wide driveway. So it's adequate to serve the intended use, which is continue to use and function for the farm, but also to serve for the proposed house. The house is proposed to be located in the corner closest to where that right-of-way enters the property. And I can point that out on the aerial, maybe a little clearer. It would be down in this corner here. So we're avoiding interfering with a major portion of the farming operation, and we've intentionally kept the proposed dwelling in that southeast corner to minimize the disturbance of the farm operation for the site.
What is the eas-
Where's Cahoon's Lane on that? So we have a better idea.
So Cahoon's Lane is here.
Okay.
The access that's shown on the other drawing comes in at kind of a diagonal here and then comes down to Cahoon's Lane here.
Thank you.
What does the easement say regarding the dimensions of the easement?
There is no set width to the easement. It is basically just a deeded right to pass and repass to enter Brendan's property.
How often do you use that right away?
Daily, multiple times a day.
I would think so, farming.
Would the amount of times using the easement would be less if you lived on the property?
Absolutely.
Can I ask you a question, Ralph? Based on the court case, okay, there were a lot of things that were supposed to be done. I've been to the site as a the vice chair of the Ag Commission. I've seen everything that's there. Is everything that was supposed to be taken care of, taken care of?
Took care of. I've received a letter from the engineer, SSB Engineering, March 8th, 2023, that I'm just taking a piece of it off. The structure does comply with the current building code, but it's got a lengthy letter, and he stamped it. And that's what I needed to make sure that building, because it's a metal structure, and there's a lot of stuff I couldn't really see what I wanted to see. So that's when I asked the Lords to get an engineer to look at the building, give me a report. They looked at the building, did a report, and the deficiencies that were noted were fixed, and that's where I got the final letter, that it's meets building code.
Like I said, I've been on the site. I saw where the house is supposed to be. It's clearly uphill, uplands there. As far as the farm went, if I was there to inspect the farm, I'd say that it was a clean farm.
okay, Attorney Blake, I'm still confused about this grandfather.
Sure.
Is this, I mean, this is the essentially the first set of bylaws, zoning bylaws that the town had in 1957. This, I mean, this seems to be really open-ended to me.
It does to me as well, right? Vacant lot having less than such minimum requirements as area, frontage, or width.
So
It has
would that mean
zero
that any lot
frontage.
that was a registered lot in 1957?
That someone could have built on in 1956 before their thing is eligible for being built after 1957.
It would appear that the literal interpretation of that is correct. However, I think less than such minimum requirements as area, frontage, or width. Frontage being, it's 100 feet, this has 0. There was no ability to access it.
Right.
So I don't know how that could have been a buildable lot with no ability to access it.
But there is an ability.
But
to-
now there is an ability. I don't know if they had that ability. Was the easement in place prior to?
I'll let Steve.
I did not research that part of the title. I was really looking for ownership overlaps and seeing if there was an ownership overlap.
And I did see you listed everything out
Right.
to common ownership.
Correct.
I assume the easement's in his deed, and does it refer to a deed that's before 1957?
Well, it was owned by his parent, or by his father, so let me just pull that up in front of me.
Thought they gave us.
I think it's in the package too, but let me look. So his deed refers to said premises are conveyed together with a right-of-way to the grantee across the premises conveyed by Quinton D. Lord and Donna M. Souza Lord to Quinton Lord by deed dated September 21st, 2017. And then it refers back to a further deed. So I think ultimately to answer that question, we'd have to chain it back.
Right.
There was,
So, Mr. Chair, to get back to your question, I think that there are some open questions here, and I don't know if council would be willing to put together a memorandum to try to walk us through these open questions.
Certainly, I just need to know what they are. but-
Because well, you know, I think what you need to show is that there was at least some type of access to that lot back there in 1956, because the bylaw changed
Right.
in 57. This is the first I've seen of this document. I'd never seen it before, and I've done a lot with these guys. I don't think I've ever seen this.
It's on the website.
All right, that's fine. But I think I would be more comfortable if you were able to provide me.
Sorry, just confirm with the client to make sure.
Okay, yeah.
So yes, we'd be willing to table or continue whatever the right nomenclature is to provide you with whatever
Okay.
memorandum you want.
can you trace the ownership back to prior to 1957?
Yes, we took every abutting parcel back well before 1957. I think the lot that probably we didn't chase back further than, I think, 1940 is probably where we stopped on some of the parcels. But we got most of them back, some of them to the 1800s, some back to the early 1920s. But yes, we went, for all of the abutting properties, we went back before 1956.
Well, what I'm interested in is this property, what, what's the history of this property so that we can determine where it fits in with zoning?
Yeah, I mean, we have deeds on this particular property. We looked at going back to, Margaret Souza owned it back in 1926.
And has it changed since then? I mean, has it just been passed on, or has it been parceled out?
No, it has not been parceled out. It's been the same parcel going back in time.
Parcel land,
Yes.
okay.
Now, the research that you did you just look up book and page, or were each of the deeds read what I'm looking at is, were any of the deeds potentially showing any kind of rights-of-way access, legal access to this property, even from an abutting property?
I think there was in the deeds, but didn't want to say that. I think that's what the attorneys were just talking about, that's something that the board, sounds like you're going to look for that information. We can provide that information to you.
The other question I would have for our attorney, is it likely or possible that, that subsequent to the 57 town meeting in which we adopted zoning, is it possible that there could have been some subsequent changes, restrictions, whatever that might affect that?
The only thing that it would affect would be, it would make it more beneficial to them, because in the grandfathering, you look at immediately, but if it was a buildable lot, and I think we're gonna need to look at the access issue, if it was a buildable lot in 1956, and it became unbuildable based on the dimensional requirements here, when you adopted zoning, then it's a pre-existing non-conforming use. And I think that, moving forward, it's not likely that it got less stringent. It's likely got more stringent, but it's protected at this point. So I don't think that we necessarily will have to do the analysis going forward. He's at least pinpointed the date at which the zoning was adopted and probably became, I don't want to say non-conforming, pre-existing non-conforming. I don't know if it was lawful. That's the issue. Was it a lawful buildable lot prior to zoning, even though it didn't necessarily have sufficient access? I'd like to see the easement, because that very well may provide him with sufficient access, and it may very well, based on the plain language of this amendment, he very well may have an argument. He very well may. I'd be interested to see what the opposition has to say, but.
I just have one, it's more than an administrative thing than whatever, but your petition actually identifies two owners. Isn't the current deed just a single owner?
It was changed, so interesting nuance here. His name is spelled Brendon. There was an error in the prior deed spelling his name Dan. As a result of that error, which was discovered, he had an attorney in New Bedford do a new deed so that just his name is on it, spelled Don.
Right, but the application showed two owners.
And that was correct at the time of application.
That was correct at the time of application?
Correct,
Okay,
yes.
Okay. That's good.
And then I made matters worse because I submitted an appearance saying I represented Lord Farms, and Maria had to email me and ask me why.
Yes, and then we spun around for a little while, but yes.
Now, that transfer from 2 to 1,
Yes.
did that take place in April of this year?
You know the date.
April?
Yeah, it should be in the opposition deed.
Sorry, I
you're-
broke it all apart.
Well, while you're looking, let me also mention.
Yes, April 11th.
Yes, and the application to the zoning board was in May, right?
Thought it was.
17.
So before or after?
The application was filed after the deed to Brendan along.
So apparently when you filled out the thing, you still thought it was owned by two people.
Well, the property
what?
record card to that too, so it might have been just to try to I would say they may have done it to be consistent with the property record card on file with the town.
And I don't think it really matters.
Right.
I'm just trying to get the facts on the case.
And just for our attorney's sake, the original right-of-way was conveyed in 1919, except obviously I can't find that deed online because it only goes down to 46, so they'd have to go to the registry of deeds to see what that said. I mean, I'd be curious to see if there was any specificity right away.
The one thing I'm still having difficulty with here is, I mean, I'm reading this and it says, okay, the vacant lot having less than the minimum requirements for area, frontage, and width. I still have a problem with 0 being an allowable, I mean, I can see.
Less than,
If it
yeah.
was 10 feet, if it was 50 feet, it was 35 feet, but 0's.
This is the
I still have
right-of-way.
a problem with,
But there's a right-of-way from 1919. So there was frontage.
wouldn't, no.
The right-of-way is
I don't-
frontage.
No, right away isn't
Access.
frontage.
I don't know.
Well, then I guess my lot is I mean, I don't have, I'm on a, my frontage is on a right-of-way. And there's plenty of them in Westport.
It's an easement, not a right of way. You have an easement for that piece of land.
And I have, yeah, so do I.
Something different than.
And there's plenty of, there's
He has a
everything
deeded
under,
right-of-way,
yeah.
which is different than a right-of-way.
I mean, I think it's worth getting a memorandum from you to straighten that out, but I understand your question, Mr. Chair, and I thought the same thing is less than such minimum requirements as area, frontage, or width. I mean, 0 is less than 100, but I would, I think we need to go back and see if at the time of creation, it actually did have, or at the time of the bylaw, it did have some type of access. And then I guess we'll have to assess whether or not that was sufficient. But I think he's gonna provide us with
Yes.
deed
Certainly.
and language.
So for the subject, my homework, it sounds like, I just want to clarify, provision of a copy of the original right-of-way along with all the deeds for this property from 1900 to the present day. Would that be sufficient?
Anytime before 57.
And then would it,
Before 57, it's fine.
would it also provide the board clarity, Steve, not to give you extra work, but if Steve could then take the legal description of, in each deed and map it out, so we gave you a picture and a deed on each transfer, I think the illustration would probably be helpful. Can you do that? like, on each deed? Yeah. Is there anything else that the board
Yeah, I
wants
would-
title-wise?
And I just by the quick look, that one of the original deeds to your dad was from Souza Lord. So I actually want to make sure that there's, even though their last names are different, they're truly not common ownership because they weren't related by marriage.
Okay, all right. Who's Susan?
I mean,
Sousa Lord was my father's wife.
right. And I think that was, but there might be other property, I think, the title search gentleman said something about, I think there was some other properties owned by Sousa's around the property. That's all, just to make sure there's no, that there's, I just want to make sure when you go and look at who owned the property when, that there really wasn't a relationship that was there that is not evident by the fact that their names are different.
Okay.
And I suppose while we're at it, you'd also have to show that it never, that from, it never became in common ownership with anything.
Okay.
Right, even though the date it wasn't in common ownership, 10 years later, it could have
It
become in
didn't.
common ownership.
And then, yeah.
And then
It
split
may have
off
been an
again.
issue.
Okay.
Any other questions from the board before I open it up to the public?
I have a very quick question on the variance.
Okay.
So it's soil, shape, or topography. So you're just, the only one of those three is you're using is the shape.
All I have is shape, you know, I know you know that, but yes, that's what we've got.
Yep. Yep.
If there are no other questions, we'll open it up to the public.
Would he need one more thing, would he need a variance if this,
No, probably not.
so then it wouldn't matter about? okay.
Probably not.
And that's why I argued it in the alternative, because if we start with the premise that it's a grandfathered lot, we don't even get to the variance discussion.
Anybody? Name and address.
Good evening. I represent abutters Joshua and Catherine Sadik,
Your
and
name, please.
Robert Feingold. I'm an attorney in New Bedford.
Speak up.
Robert Feingold. I'm an attorney in New Bedford. I represent Joshua and Catherine Sadik, who are abutters at 40 Cahoon's Lane, and Joshua's dad and mom, Richard and Coral, who live at 46. I have a lot to say. The zoning law is not focused on one thing. There are a lot of requirements before you can get a variance, and they have not satisfied all of the requirements. There's nothing about the shape, the soil, or the topography of this lot that's in any way creating a problem. It's not unique. What my brother had to say was not persuasive at all. That's number one. Number two, all he could say about hardship is that his land, his current house is for sale, and it would be a hardship if he lived in Dartmouth. I think there's a lot of people in Dartmouth who would object to that, but that's speculative. That's speculative. He can take the house off the market if the variance is denied. It's not under agreement, so there's no particular hardship there. The research I did, sir, was that under Westport Bylaw 7.6, even if the lot is grandfathered, it has to have a minimum of 100 feet of frontage, not 50. So 0 doesn't work either. We're going to take another look at the easement. We don't think it goes all the way through to his land. He's in violation, he has been in violation of the litigation settlement because it only allows for the crushing and removal of rocks on the property. He has been bringing rocks into the property to process them. That's a violation. And all the violations that he was guilty of that created a massive litigation proves to me, and I think it should prove to you, that the man, if you give him an inch, he'll take a mile. He's not to be trusted. "10 feet for a width of an easement is not enough for emergency vehicles. I think everybody would agree to that. I submitted a detailed memorandum for the first meeting, and I would appreciate seeing my brother's memorandum and having an opportunity to respond to it. Thank you.
Nicholas Ratcliffe, I don't know what address you want me to use because I was 59 Cahoon's Lane. I am now currently 48 Cahoon's Lane, 7 years after my dwelling was built. So that's the circus I'm going through. Second of all, the lawyer that is defending his client just spoke about Mr. Lord bringing in rocks. That is totally false, okay? I've been there, I witnessed it, I grew up there for 35 years. Grew up with Brendan, okay? We all grew up on the lane. I grew up there. There were 7 houses on that road, okay? Prior to that, me speaking, something got passed along the way, and now there's about 14 houses on the road, okay? Yes, they might have the frontage, they might have that, but the lane's changed. Brendan always had his right-of-way up there. We've always went up there. We grew up there. Raise a 9-year-old and a 7-year-old that are here tonight that play with his 3 children, and to destroy Brendan's dream of building a house to raise his family in, that his house is for sale, that you're saying, oh, they can take his house off the market. I think that's absurd, right? So I don't understand the fight. Yeah, Brendan makes noise up there. He farms. If you don't like it, shut your windows. Turn up your AC. I don't understand. Everyone that's here to fight it, It's all family down that lane. I built a house across the street from my father. I purchased the lot, built a house. The people that are fighting this are the people that were gifted the land that Connie Cahoon owned. And they're raising their beautiful family on the land. All Brendan's asking to do is to raise his family, farm his land. He's not disturbing anybody. Yeah, I get it, there's laws, this, that, and the other thing, but it's not much of a hassle for Brendan to drive through. It's an easement up to his property. So I hope the board would take that into consideration and let Cahoon's Lane keep the ownership of the old family history and let the kids just frolic and play, because we all get along. Everyone gets along down there, and there's no reason for people to fight this and argue this and spend money and waste everybody's time because someone's upset about Brendan crushing rocks out back. All them rocks he crushed, I've been up there countless hours with him, watching him dig it out of the field, so when he's harrowing the fields, he's not messing up his machinery. I've seen the piles of rocks he's dragged up. They're not bringing rocks in. So that's what I have to say, and thank you for your time. Appreciate it.
Anyone else?
I'm my family. I own a lot, 22, and I have no problem. I don't have any problem with family members. Brendan and company have been great.
Before you say anything,
Sorry.
Name and
Yeah, my name is Fred Magalhaes. I go by Fred. My name is Fernando Magalhaes. I own the lot. Brandon been there a few times. I have no problem with them. Good families. I got to say though.
What is your address, please?
22 Cahoon, which is the lot which has the easement. When I bought that land, I bought it to build my retirement home. I bought it so that it'd be nice and quiet. I have no problem with farming. I love farming. That's part of the reason I bought it, because the farming is going to be behind there. This crushing stones, because I don't live there, I didn't even know there was crushing stones, but that would bother me going forward. Because if I'm retired at home, I don't want to hear crushing stones. Now, I got to believe that a farm, there's only so many stones that can get crushed, so I got to believe that eventually that'll stop. I don't know if that's true or not. But I did buy that because it was an easement. I was told that that easement was only for farming, and only farming equipment would be going by there. So that's what I expect. I don't live in the land yet, so I don't see a lot of the activities. But certainly as soon as I start building, I would like to have less traffic than more traffic. If you build a house, again, Brandon, I don't know if there's going to be more traffic or less traffic. I prefer less traffic because it's dust. You have your windows open, right, if there's a lot of traffic. Farm-wise, I love the farm. Love and that's why I bought it there. What I'm hearing today with the crushing, that would bother me, of the stones. So I just want to share that with you, because I will be building a house there soon. And I bought it because it was a nice, quiet road, and I want to keep it that way. Again, I have no problem. They've been good to me. I want to be good with my neighbors, but at the same time, I don't want to be taken advantage because I bought it because it was going to be a quiet place to live.
Thank you.
Thank you.
Hi, good evening. Catherine Sadik on 40 Cahoons Lane. Our attorney already spoke, but I do just want to address some of the comments that were made, especially on Mr. Ratcliffe. We witnessed rocks being taken from Mr. Ratcliffe's property to be brought onto Mr. Lord's property, and those are some of the rocks that were crushed. So for him to say that rocks were only used from the property and not brought from outside is just not supported by the record, and he should know that. Now look, my husband's family has lived on this lane their whole lives. We support farming. We have no issue with that. But for years, there was commercial activity going on in that property that was not farming, that was extremely disruptive, okay? All I want to do is raise my family in peace. And we couldn't, because month after month, day after day, there's commercial activity going on in that property that was not supposed to be happening, that was disrupting our lives and our ability to enjoy our property. I don't care what someone else does on their property if it doesn't impact me. But when someone's doing things on their property that they're not supposed to be doing, and then claiming it's farming repeatedly, that's a problem. And that went on for months. Mr. Lord resisted the town's efforts to investigate it and claimed that everything was just farming. And eventually the town had to invest, I don't know how many thousands of dollars in resources to bring a lawsuit over it. And in the course of the lawsuit, finally, Mr. Lord admitted that there was all this non-farming commercial activity happening on the property. And that's part of the concern here with this variance. That if there's a variance, there's a history of conduct that's not supposed to happen taking place, and there's a history of saying it's one thing when it's actually something else. And that puts the burden on the rest of us. And I'd be very interested to know if Mr. Lord would swear under oath that there's no commercial activity going on that property now, that he's not repairing vehicles for other people on that property right now. Also, as our attorney referenced, I think there are issues with the easement that need serious review. There was an easement, and then it was relinquished. And now there's a new easement, and at least as best I can tell, I don't think it even reaches the property. And so I think that's another serious concern to raise. We're trying to be good neighbors here. We're not trying to create a controversy. We're just trying to protect ourselves. And we have concerns based on this pattern of past conduct. And we have concerns that it could lead to more of what's been happening and more of the uses of that property that disrupt our ability to enjoy our property. Thank you.
Anyone else?
I would like to ask a question, please, to the applicant. Are you actively doing commercial activity on that property?
What is your definition of commercial?
I'm sorry, what?
What is your definition of commercial? Is farming not a commercial?
Farming is allowed, and you know that.
Okay. I am.
About commercial property activity that is not farming.
No,
By the way, crushing a stone, bringing stone in and crushing it is not necessarily a farming activity. This board has actually shut down some operations in this town on Main Road that was bringing stone in, crushing it, and processing it, and it wasn't stone from that property. So I'm asking you again, are you doing any non-farming commercial activities?
I am not doing any type of commercial activity aside from being engaged in commercial agriculture.
During that commercial agriculture, do you have to repair equipment?
I do.
Do you have to use welders?
I do.
You have to use grinders?
I do.
Those are all things that simulate. I mean, I do it on my farm, and I have to do the same things.
But is it for you, or is it for somebody
Just
else?
for me, I mean, if I have a commercial, just like he does, and if my baler breaks down today and it's parts that need to get in there, and it snaps in half, I'm welding it back together.
No problem with that. If
But
it's
that's
yours-
not, that's commercial farming.
As long as he's not doing it for somebody else.
Correct.
As long as
Right.
he's not repairing your
Right.
hay baler. As long as he's not repairing your hay baler on his property.
I might have to have him come and weld mine.
We know Brendan's a respected diesel mechanic, and so I could see where that could happen, but that's not what we're talking about. And that's not directly related to what this hearing is about either. That will come later, if you're allowed, and if you start doing all these other things.
And again, have you inspected this place recently?
Recently.
And there are no violations from this court?
That's why the report was done back in '23, where the building met the building code. The corrections were made and the engineer signed off on it.
As a matter of fact, I think when Ralph had come up to do the inspection, I was over with the cows and Ralph went in the building.
All
or open the door of the building. And what's going on in the building, Ralph?
Not a thing. Like storage, a lot of storage in it.
I just want to advise the audience that we talked an awful lot about grandfathering. If in fact the petitioner can prove that his property falls under the grandfathering clause of our zoning bylaws, then he doesn't need a variance. So there's two separate things here. If he can't, then he's required to, then the variance part of this comes in, and he will have to talk about all the things that the other lawyer had mentioned as far as the hardship and all of that. But if the attorney for the petitioner can prove that in fact this land is grandfathered in as a buildable lot, then he doesn't need a variance. Isn't that correct?
I think you're right.
If I may. Bylaws. As we put in our original brief that we filed a couple months ago, bylaw 7.6 says if it's grandfathered, even if it's grandfathered, it needs frontage, 100 feet.
Well, that's where the lawyer, we're going to have to investigate that much further. So, are you going to request a continuance so you can
Yes.
provide additional information?
Yes.
We have the form set up for that?
What name do you want me to put on it?
Attorney Blake,
Yeah, Mike.
can you look into the current bylaw and how it impacts if it does?
I can see it right here. It's, it does say, the current version of Section 7 intensity regulations pertaining to frontage and/or area requirements shall not apply to a lot for a single-family residential use, which at the effective date, 1982, of this bylaw amendment was not held in common ownership with any adjoining land and had less than the current requirements, but at least 20,000 square feet and 100 feet. But that doesn't mean that he couldn't have been grandfathered in the very beginning.
Beginning, okay, all right.
And it doesn't
Again,
matter
this
that
is a
the
legal
property
thing
has
that the
changed
lawyers are
hands?
going to have
It
to.
has not changed. I think a
Yes, it has.
grandfather property can change hands.
Okay.
As long as it doesn't change configurations or become owned in common with another.
Okay. That's when you lose your grandfatherness if it merges with something else?
It could.
For purposes of the request, what is the date that we're looking to continue to?
I scheduled something for August 6th.
Ask.
Yeah, it's only a dog issue. It's only about a dog.
Oh, okay. Is that acceptable to,
It's fine with me.
is that sufficient time?
I think so. Bob, how much in advance do you want me to send you the title work? Is like a week okay, or? 10 days. Okay. All right.
Before we do that, Attorney Blake,
What,
you-
August 6th?
I'm available then.
you're available then?
But I also want to say
Yeah.
that we have 100 days
Right.
to act, unless there's a written extension, to act, and then 14 days after that to issue an opinion.
Yep.
So I would ask that you give us the extension to August 20th. We'll hold the hearing on the 6th, and that way, to the extent that there's any decision that needs to be made, we still have
Yep.
adequate time to do it.
No problem.
Do we
So
know
put that-
what the current 100-day date is from the beginning of the petition?
It was filed on April 17th.
Yeah, we'd be past it.
And are there fees due for the additional continuances?
There is.
Okay, just,
So you do, yeah, that should be sent up to the town clerk too, when you get a chance.
So sorry, how much money does he owe?
$100.
$100. All right, so you got to pay $100. Jeff, what language do you want relative to the 100 days?
I just need, you agree to a continuance, of the hearing on the variance and on the pre-existing non-conforming use, use, I guess it would be, till August 20th.
Is that for the actual?
No, your hearing will be on the 6th.
Right.
But just in case, we need time to issue a decision.
Right.
So we don't want,
Have to do this anyway.
yeah, but if the 100 days expired on the 6th,
Oh, I see.
Comes close. Yeah. Isn't your standard language saying you're also agreeing to extend the deadline?
yeah, to
Yeah.
August 20th.
Yeah.
Yeah.
I think it's standard that it extends it.
So I wrote,
Really? Oh.
applicant agrees
knew?
to a continuance on the variance of the pre-existing non-conforming use to August 20th, 2025.
Yeah, that should work. Should give us what we need.
So you pay her $100 tomorrow?
You-
He has to pay tomorrow, right?
Yeah.
Okay.
You have to actually ask the board for the continuance, and then we vote on it.
Yes, certainly, and I'm sorry if I was out of order. I thought that I made a motion earlier to continue, but I'll make a motion to you that the applicant would ask to continue this petition until August 6, 2025 for a rehearing. Furthermore, that the applicant consents to an extension of the 100-day period to August 20th, 2025 on the pre-existing non-conforming lot issue as it relates to a variance.
We have a request, you have a motion?
Yes, I will move to continue this hearing till August 6th.
At 6:30 here in the town hall.
If you want at 6:30, we already have the
Oh, well,
dog one,
we still put 6:30.
all right?
I'll second that.
Any discussion? All in favor, say aye.
Aye.
Aye. All opposed, no. That's granted.
Thank you.
Do you understand then what
Yes,
your marching orders are?
I do, and if I don't, I'll email Attorney Blake, and I'm sure he'll indulge my
Is that
request.
okay, Attorney Blake?
Yeah, absolutely, absolutely.
Yeah, what we need, I mean, you know, we need to know enough to be able to identify whether this can be grandfathered under the zoning bylaw. In other words, you know, what is the easement? When was it in? You know, is that, you know, who owned the property at all those times? And all that stuff that's going to convince us that in fact, that this property could be grandfathered. You're gonna want to have to convince.
Yeah, I was going to say, I will do my best to convince you. Thank you.
Thank you.
Have a good night.
See you in a month.
Thank you.
Okay, I'll wait till everybody
Yeah.
files out.
Yeah.
Okay, the second hearing tonight, let me see, where's my, here we are. 12 Old John Reed Road, application of Patricia Ellis and Glenn Ellis for a variance from the frontage requirement and to increase the height requirement from 40 to 45 feet of the lookout tower as mandated zoning bylaws, Article Section 7, Section 7.1, 7.2. The property is located at 12 Old John Reed Road, Westport, Mass. And shown on Assessor's Map Lot 76, Lot 107A. Voting on this will be, is everybody, oh, okay. Jerry Coutinho, Ray Elias, myself, Roger Menard, Cynthia Kazekowicz, and Janice Day. Again, the process will be the same as before. We'll have the petitioner come up, provide whatever information is pertinent. The board will ask questions, in which case then we will open it up to the public. So come on up here and identify yourself. Before we get too far, I am going to read a letter from Ralph, oops,
It's not me.
not you, it wasn't you. Oh, this was Randy was
I
acting.
was out.
From Randy Bissett. The building permit application for the proposed new 44-foot, 3-inch height, three-story structure at 12 Old John Road is denied for the following reason. The town of Westport bylaws maximum 7.2 maximum height, a dwelling hereafter erected or replaced in the residential district or in the business district shall not exceed either 2.5 stories or 40 feet in height. In order for you to proceed with the project, a variance is required from the zoning board of appeals. So that's what brought us all here. So you're up.
All right. First,
Name and address.
oh, sorry, Glenn Ellis and Patty Ellis, 41 Oxford Road, Charlton, Massachusetts. We are also abutters to 12 Old John Reed Road at 101 Old John Reed Road. Can I assume you're familiar with the property?
I am.
12 Old John Reed
Yeah.
Road?
Yep, right down by the beach.
Yep. It's, the lot is pre-existing, non-conforming. There's a house on it now. It was deeded at 100 feet wide. When we had it surveyed, it came out at 94. So we're going with the 94 because, you know, that whole area, all the property lines are all over the place. So we'll eat the 6 feet if that's allowed and keep it at 94. So it's short frontage. And the second part, when we did,
So it was originally deeded for 100 feet.
correct.
It's just when they
And when we had it
they
surveyed, it wasn't quite 100
Didn't
feet.
turn out to be 100 feet. Yeah, I mean, that happens like everywhere in
Yeah,
Westport.
all over.
Right. So we're willing to say, okay.
Oh, you're willing to say, okay.
Yeah.
Oh,
But if you were willing to say okay also, then
Justice,
go
we're
with
we're the ones that have to be.
a lot
willing.
that's under
Right,
100.
but we're not protesting the deed, we're saying it's, it is what it is. And the other issue is, and then when we went and applied for the building permit, it was both the main structure and the tower that were tall. We have since reduced the main structure height, which are the plans you have, to 40 feet. And then there's a tower that we would like to bring up to 45 feet so we can have a third floor with a lookout.
Right, and neither of those meet the requirements of the zoning. You can't have a third floor, and you can't have above 40 feet.
Correct,
It's not a habitable space.
It's part of the house.
Got it.
all right, it could be a half a floor. There is an elevator that requires going up above the second floor, because the mechanism for the elevator will be above it. So we will have to bump into that space. So whether it's attic or half a floor, it's required by the elevator.
Is the flood zone the same on East Beach as it is there?
Flood zone is a V19.
What does that
Is it
mean?
the same on
It's
East Beach?
elevation, the flood elevation for VA19.
So they're all on stilts?
19, they're all on piers.
Correct.
And
So is it third floor just because of the stilts?
No.
No.
Okay.
No,
Oh,
it's-
it's really almost 4
Go
floors.
through the drawing to help them.
So,
There's the reason for the extra 5.
Okay.
so if we
The
allow
house meets your 40.
from 40 to 45 feet, we would be
They want
opening up
this
a can of worms in the
lookout.
flood zone area because everybody's on
And
stilts.
that's what they were the extra 5.
Right. And that's part of the hardship is you have to start at
Well,
16 feet and go up.
That's
And the
part
40
of, that's part of the,
I beg to differ, though, because according to your plans, the house is fine at 40 feet.
Right.
On the stilts.
Right.
So it's not a hardship for the house. The 40 feet is not a hardship to build your 2.5-story house, correct?
Understood.
Correct.
Right? It's only affects the extra tower you want to build. Okay,
Which includes an elevator.
well, okay, whether it includes an elevator or not is,
And one of the things we're trying to do also is make a structure that is appealing and not just put a box on stilts, so that the tower is an architectural feature that is part of the look of the house. It's also functional because it has the stairs and the elevator. And it's the only piece that goes down to the ground with breakaway walls. So most of the houses that stilts are boxes on legs. We're trying to avoid that.
Should I go through the plans?
Sure.
Okay. I'm Cindy Sachs. I'm 1301 Horseneck Road, and then also 18 Moreland Ave, Newton, Mass. So what I thought I'd do is walk you through the different plans, same as you have. I've also included the survey plan in this. And I think I'll primarily address the height because the 94 feet may be less of an issue. So as you can see, it's a very large lot. It's over 2 acres. And the abutters have signed off on this and said it's acceptable. So there wouldn't be any, the house will not block anybody's view, in other words. Across the street are the campgrounds, and it's a pretty empty area, and they live next door presently. Presently, there are a number of structures all over the site and a small cottage. We would be removing that, removing the asphalt driveway, and basically building a box with a tower next to it and a number of decks.
I like your thing with setbacks, at least plus or minus 565 feet.
Yeah, kind of.
I assume it's just way back there.
Yeah, that's right, plus or minus.
It does go back to the land.
I take my measurements very seriously, seriously.
Well, I wasn't quite sure what the plus or minus was, but
Well, I like doing that every once in a while. Right?
in other words, it's roughly 565 feet.
Yeah, it could be 1/8 of an inch more, 1/8 of an inch less.
Or another surveyor could say that their property line doesn't go as far as they think it
I was
does.
thinking, if it was minus
lose our
565 feet,
Yeah.
does that make it the other direction? Go ahead.
So the ground floor will have a number of piers, and then it'll have a 16 by 16 foot structure that will have a stair, an elevator, and a little storage, basically an entry. It'll all have knockout panels so that it'll be acceptable in the flood zone. The first floor will have bedrooms, 2 bedrooms, utilities, and 1 bathroom. And again, the tower with the elevator and stair. And part of this is as the Ellis's age, I think they're planning on living here full time, and they really do want the elevator.
That's the purpose for the house, is we're planning to retire to this point.
Right. And they've been coming here for 60 years? I don't know. I don't want to know.
It's been since the 70s.
It's pretty standard in houses on stilts that they put elevators in because
Yes.
there's.
It's hard to get up 25 stairs.
Yeah.
And of course, it'll have decks which will take advantage of views of the let. The next floor would be a living space, again with decks, and the elevator would go there and also a stair. The top floor, which is in question, the deck floor, would be, is it 2.5 stories or 3? So that's a very good point. Will be access to the small deck here. And the stair would go up to that level. So the elevation here, the west elevation, is what you would see from the front of the house. And I'm really trying hard not to give them a box, because all the ones going up are basically a box with, sitting on stilts. So it would have a small deck, and then this is the entry for the house, parking underneath. Again, the side elevation, the south elevation would be hip roofs and windows for the tower room.
Excuse me,
Yes.
while you're on that.
Yes.
That one, I don't have any dimensions.
What dimensions would you
shown
like?
Here. So what I'm trying to figure out is where is this extra height?
Oh, go to the section. Give me like 2 more boards, if that's okay, and I'll bring you to it.
Okay, you can stand that board for a second, or actually any of these. So if you
hold
lowered,
something
if you
better.
lowered your outlook by 5 feet, then this wouldn't be a problem for anybody.
Well, wait, if I lowered the what?
If you lowered your outlook, your,
Yes, but you wouldn't have headroom to, you couldn't lower it by 5 feet.
why? Why? There's nothing else, what's the,
Oh, I see, you're saying just,
But then they wouldn't have the tower, and then it would be a box.
no, it'd still not be a box. You still have that, it would just be 5 feet lower.
understood, yes, you are absolutely correct, yes. It would just be a piece on the side of it.
Yes.
Yes, it would be.
In which case, then-
It wouldn't be a lookout, yes,
It would still
that's
be a lookout,
exactly.
it just wouldn't be as high a lookout.
That's right, that's exactly it. And you wouldn't really look out there because you'd be looking at, we played around with this. It's not out of the question. So when you bring it down here, there's nothing really you're looking out on much. It's the same as everything else.
Can you still access the,
Well,
the deck on top if you go down 5 feet?
Yeah.
Door.
but
You have to access
but a
it
variance for a better view is not really a reason.
Right.
For architecture, I see the purpose of trying not to make it to a box.
That's not a rationale for a variance either.
Yeah, but
Understood. Understood.
See, in order to grant a variance, you need to identify a hardship. And according to your documentation, your hardship is because you're gonna put this thing on stilts.
Well,
And that-
because
and
we're
that raises
starting-
it-
So we could put it on stilts, but if we didn't have to start at 6 feet,
Yes,
the
but your
elevation.
2.5-story house matches the 40-foot requirement for our zoning.
Understood.
So it's hard to say that you have a hardship because you want to add an outlook.
Yes, understood. Yeah. And the last one, which will answer your question, is all the heights. So basically, what we're looking at is we're starting the
You should
first.
have that as your last page.
It's also listed in the front, but
Yeah. So the finished floor of the first floor is at 16 feet above grade. So and doing that, it just squishes everything down. We went to a lot of work to keep the angles of the roof as best we could, sort of a New England style, and trying to
So from grade of the first floor to the top of the,
finish floor 16 feet,
but from there to the top of the peak of the
26
lookout.
feet.
So it's still within,
it's 40 feet to the top of the house.
no, I'm talking about to the top of the, I'm saying if you just say,
Yeah.
Oh,
Yeah.
it's 26 plus 5, so
Right
it's 31.
Closed.
right, but minus
That's the
16,
house, and that's 45.
right.
I'm still trying to figure out
What's that?
where the 5 feet that you're looking for are.
Right there.
They're right here. So it starts somewhere right about there.
Right.
And it's basically, most of it's roof. There's a chance we can start the first floor a little bit lower or higher because I use 6 foot as an elevation. It's plus or minus a little more than 6 feet. It's maybe closer to 7 in some spots, but I was trying to be very conservative. But yes, so you go across, actually, the way you could tell is go straight across here, and that's where you'd end up.
The ridge line of the main house is at 40 feet.
Exactly at 40 feet, yeah.
Ralph, have you looked at this?
This is the first I'm seeing of it, because,
Okay.
again, it was spoken to me
because-
before I went out.
Right,
Yeah.
When I went out, I went to Randy Bissett.
right.
Randy
Okay.
Bissett generated the letter. My question is,
What's that?
did you apply or did you ask for an opinion? Did you apply for a building permit and get denied the building permit, or did you ask for an opinion?
We went to Randy, and he said, apply for a permit, and I will fail you.
So that's what you did.
I will deny it, yes.
Okay.
That's what brought
And
us here.
and then he said, and then ask for a variance.
Right.
Could you make the shape of the roof of the tower to mimic the shape of the roof of the house, where you sort of flatten it up a little bit?
So I said if they dropped it by 5 feet, then it would all be, good.
Right, it would be a flat roof if they dropped it by straight 5 feet.
Well, no, it would just be,
You would, but you wouldn't, you would only be, I'm short, but it would only like be 4 feet. I tried, because I considered doing a totally flat roof there.
well, no, you've got a lot of room underneath it.
I mean,
Yeah.
here.
No, down below it.
Oh, you mean drop it here? This is because of the elevator. This floor right here is because of the elevator overrun. But you're right, you could bring it down slightly. I mean, if you can give us 2 feet or 3 feet, I may be able to do something here. But it's tough. It really is. To make something, you know, the expense in doing it, which I know is not a hardship, to do it if you're barely making it work, there's no point.
But is this,
Yes.
I'm still having a hard time figuring out. Is this solely for an elevator shaft? Or is it because you want to have room up there to sit there or have
That's
decks?
it. It's more to sit there. The elevator shaft, because it's an overrun and it goes up to 9, it needs 9 feet. So if this is a 8-foot, these are rough numbers, finished ceiling, then it pops up. So we can bring this down 1 foot, but then we have this bump up here.
Yeah, but the purpose for that is an outlook,
Yes, it is an outlook.
so that you get a nice view of Westport Beach.
Right, right.
And that's
Or the
where the
red.
issue is.
And you can probably even
It's-
see
if they-
Bayside from there.
It's the let and the
Okay.
sun sets, because you can't really see State Beach. The dunes are pretty high.
Oh, the other way, yeah.
Yeah,
No.
yeah, yeah.
If the house wasn't on stilts, how high would it be at its highest?
31 feet. How's that one for you? Except for it probably,
So you're within 40 feet, but you're only,
oh, totally.
right. And the only reason you're at 45 is because of a state requirement that you have to put it on stilts.
Yes. Yes, that's exactly correct.
But
And
they meet the requirement for the house on the stilts.
And that could end up all the way up and down East Beach.
Yep.
all the way, oh, I mean, other
Well,
people
I mean,
building
it's-
East Beach, but I don't think anything on East Beach, they're not
Well,
buildable lots, because that's
Well,
another.
they're gonna have to apply to the flood zone thing, so.
Yes.
Right. And the elevation for the state starts at sea level, I think, or elevation.
Right, so if
whatever
you're
they
at
call
0,
elevation.
right.
So 21 feet starts there, the 40 feet starts from the ground. So it's wherever your earth is. Raise the earth up, then we could
Now,
get
Ralph,
it in.
when you, I mean, you've done this, you take like a mean area, right? Or
Right. It's
So
from the
in
high
the-
point,
if-
you average it out, you get a.
the average, that land is,
out.
that land's pretty flat, right?
Right,
So the mean is,
6.
it's
Seven.
Probably
it's the
6,
same
6,
everywhere.
Do you
It
do the
is
four
in the-
corners of the house or
Yeah.
or the lot, the
Four corners of
buildable?
the lot.
Oh, you do
Yeah.
lot, you're not
The
the
lot or
house.
just the buildable
Okay, I
part of the
was
lot?
doing-
A lot.
You go all the way back to the lead.
So we go all the way down to the let, so maybe,
That gets
Is
a
that
little-
right? In order to calculate the height?
Oh,
Calculate where the grade is, but then they also got a 2-foot buffer zone. The bottom of floor joists is gonna be 2 feet higher. That's why I asked her when they applied. So
right.
there's 6 months to act on this permit, so I'm assuming they applied about the time it went out, so they've applied. So, under my determination, if I'm issuing that permit, I could issue it under the 9th edition. If I issue it under the 10th edition, they've got a problem with an extra foot. Because I just came out of the seminar today, and it's 3 feet now in the 10th edition. We started the 10th edition. The 10th edition is solely in operation right now. The 9th edition has gone away.
and so one of the reasons we did not reapply, we talked about it, because we had applied, and because we were waiting for zoning, we were allowed to continue the.
Right, you're allowed to continue because you're in the zoning board of appeals right now,
Right.
appealing it, because you, when you talked to me back when, I said, you gotta get it in here, because I knew the 10th edition was coming on.
Yes,
And it had to be so that you get the time, and I'm not restricted by the code to issue you something.
that's exactly right.
So it's gonna go under the 9th edition, depending how far this goes.
Right.
If it goes to the 10th edition, it's an extra foot tacked on.
Then we're asking for 6 feet, not 5.
So every
What's in-
permit that comes in front of you gets treated the same with just 45 feet on stilts?
Going forward now, every permit that comes before me in a flood, let me correct that, in a VE zone, whatever the VE is, if it's VE 19, then the bottom floor joist is, under the 9th edition, is gonna be at 21 feet. It's 2 foot higher, but under the 10th edition, it's gonna be at 22 feet. It's an extra foot, it's 3 feet now, buffer.
Oh, they changed the
They
height
changed.
requirement? So they have to move it up higher.
They'd have to move it up higher if it was going under
So
the
there would
10th
be-
edition. That's why I asked her, did she apply for a permit? Because at that point, I didn't see this anymore. I was out for what I had to have done.
Yep.
And Randy took it up.
Right.
Randy, I wanted to know if Randy took an application in. He took an application and he denied the application.
Okay.
That's better.
So that started the clock. I mean, that was,
That started the clock right there.
right. So they go under that set of rules. If they have to reapply, they have to go under the new set of rules.
Right, if they didn't apply, that's why I asked if they asked for a determination, the zoning determination.
Okay,
Council
that's
doesn't like
right,
it.
okay.
But if they did that,
Yes,
Then they'd be asking
that's
for
a
6
rough.
feet.
It's- They didn't apply for it, they
Right.
applied and were denied.
yes, yeah, I got you.
Is
Okay.
there a different type of elevator you can put in there without going up to 5 feet?
Well,
I looked and I couldn't find one. I'm not an expert on elevators, but I tried really hard to find something that didn't have the overrun. I called a number of companies and I think it's just the way these go.
You want the mechanics up above because of the potential for flood.
Mechanics have to be up.
Right. Is there anything else?
We have talked to all of our neighbors and none of them
Yeah.
have any issues.
Ralph, I mean, the first part of this was the 100 feet versus 94 feet. Is there any issue? I mean, they had a deed that said they had 100-foot frontage.
And the GAS still says it's 100.
And, right, when they surveyed it, it turns out to that. I mean, is that, well, that, I guess,
It's a lot that had a house on, I mean, it's got a house on it.
Got a house on it now.
You're gonna knock that house down, build a new house.
Yes,
So
and all these other buildings.
so that's pre-existing anyway.
Pre-existing anyway.
So you might need to do a finding.
It may lead to a finding, or we can just decide to give them a variance that's, because they actually had a 100-foot
Yeah.
on
The
the
house,
deed and on the,
and the property
and the
next,
town assumed it was 100 feet.
yeah, and the property next door actually has less frontage. It's at
Right.
180-something
I mean,
frontage, so it's
I
not,
know every house on my street, if you surveyed them, wouldn't be what the deed says.
yeah.
Yeah, I have the same problem on First Street.
Did the building commissioner deny it based on the 94 feet? Because
He didn't say that in the letter.
because
We never raised the question.
I don't know if, Ralph, they've got a deed that says 100 feet.
He didn't deny it on that, he denied it on basically its
Height.
height, that's what he
Because
denied.
the only reason I'm going this way is because, as you know, a variance is shape, soil, or topography. And it sounds to me like there's a question as to whether, there could very well be 100 feet. Survey might be off, right? You got two different surveyors saying two different things, and one of them assists you. So if Ralph is not gonna, if he's gonna issue the permit because it's got sufficient frontage based on at least a deed that he looked at.
My determination of that, this is a pre-existing lot, so
In a
they got a house on it.
But if it is, then you would need to say that the new house is not more detrimental to the neighborhood.
Right, yes.
But part of,
Which would cover you.
part of the
So we
detrimental
would
is,
need to do a finding,
That's a finding.
right. But we can, because that's a less severe than a variance, we can attack that as this petition.
I think you can.
Because it's,
Yeah, I do think you can.
they've identified the issue in their petition, so whether it's a variance or a finding, since a finding is a lot less restrictive than a variance, I think that we can act on a finding rather than a variance.
I think you can. I mean, the only people, somebody may try to challenge it because it wasn't properly noticed, but as these folks say, I mean, look, the last one was full and now we've got
Nobody.
just this. So
Right.
it's unlikely to be challenged. So I think that it would probably be easier and better just to make the finding that it's a pre-existing non-conforming use and the proposed use and structure is not more detrimental to the neighborhood.
Right.
Now, we noticed it as a variance.
I know, that's what I was just
We didn't
saying.
say- We didn't say finding or, as we sometimes do, but that wouldn't be an issue.
Well, it was just, that's what we were.
That's what we were talking about.
that's
Well,
what we were
stepping
talking
down,
about.
right? I mean, if they asked for a finding and really needed a variance,
Then that's-
that'd be a different thing, but we're bringing down the
We're bringing
requirement.
Right, that's what I.
Yeah,
They asked for more than they needed.
Is it ironclad? No. But simple fact of the matter is, we're here. Why, there's no opposition. I think it's probably the way to go, and after the facts made themselves aware, you're now kind of changing the relief. Could it be challenged? Maybe. And I don't know, and like I say,
Nobody's saying.
Right.
very few people in here, and, it's, as you guys say, variance is much more
Stringent.
stringent and detrimental possibly to a neighbor than simply just making this finding.
What's the difference between a finding and a variance?
But in a finding, we,
Sorry, I'm not an attorney.
That's all right, that's all right.
go ahead if you want
A finding is, if you have a pre-existing non-conforming structure on the lot, and the issue is because of frontage, you don't need a variance. What you would need is you'd come to the zoning board and they would make a determination and to expand it or to alter it, which you guys are doing. They just make a determination that it's not more detrimental to the neighborhood.
Right.
Versus a variance, which requires, it has to be owing to the shape, soil, or topography of the lot that's different in kind than everybody else in the neighborhood. Much more stringent
Right, yeah.
criteria, much more stringent.
And a finding is a majority vote rather than a variance requires four
Yep.
affirmative votes.
Okay.
But that isn't the main issue anyway. The main issue is,
Right,
is the height.
the heights.
Right. Any other,
Well, I'm going to say again, I want to be clear. I thought from your initial presentation that the issue was you need the extra for the elevator, just for the elevator. But when you showed this, and again, it doesn't show it on here. You said this one shows.
Yes.
Okay? I don't really see much there. It says elevator over. Okay, how much of that is the elevator's
So-
issue?
so
Because
if you
seems to
look
me
at
it's
it-
more than just the elevator.
No, it is more. It's the lookout tower as well. But the elevator adds an extra foot to it. So if you look there, there's a dimension of 9 feet. And normally a ceiling would be 8 feet. But in this case, I've got it at 9, so it won't bump up into that little room, which isn't much of a room really, because it's basically a stair in there. And most of the part that does come above the 40 feet, it's not a lot of roof. There is some, not trying to pretend about anything else. But, that's it.
So you could, if you just went with the elevator,
Yes,
and you didn't have that little room on top of it,
right.
You wouldn't be here talking about 40.
That's basically it.
Like Ray, I'm concerned about proliferation of this. You might as well change the bylaw.
Understood. And it's really a question for Westport because, I mean, when I built my house 20 years ago, the rules were all different. I just had to bring it up to basically 30 inches above grade. And now for my own place, I have to bring it up 12 or 15 feet. So I get it. And as it's going to change in the next edition, it's going to change again. So I don't know how the town's going to deal with it. And
Is there any way of adding ADA compliance to this to make it? Ralph?
If in the future there's a problem, you're gonna need that elevator for accessibility.
Right.
Handicap accessibility. And it's that
Yeah,
handicap.
But they could have it without the 5 feet.
Gets a pass in some situations.
That's actually why
But-
we're adding the elevator, frankly.
Right.
If you're gonna talk, you have to go to the,
But you can still put the elevator in without the 5 feet.
That's exactly.
The 5 feet is just an architectural
right.
design
Gives you an
and,
outlet.
and preference.
That's it. They're
Which you could
totally being
have
honest.
easily just have, if you really still wanted to look at, that could just be a roof deck up there.
So here's a question. If you had a roof deck and you had railings above the 40 feet, is that allowed? Have people asked this already? I don't mean to nitpick. I'm
Well,
just
no.
trying to
No, it's
understand what one's constraints are. in
Answering
design.
that question, if you're gonna turn the roof into a roof deck,
Yeah,
by code, you're gonna need railings.
yes, of course.
It's gonna be 3 feet.
And is the 3 feet have to go with the 40 feet, correct? You know what I'm,
I'm saying no, only because it's a railing that's required. You've turned the roof into a roof deck. It's not, in my opinion, it's not a structure, it's not part of, it's a safety feature, not a structure.
understood, okay.
Yeah, I think it's been done before.
It's been done.
But you'd still have to bring it down lower because your roof, if you take out the roof of this over thing, I was thinking of more of putting it here, right? The roof, like making
Going straight across.
straight across. Or actually maybe lower for architectural, right? So you have that's the,
Sorry, I'm missing.
like I'm thinking that
If you lowered that to the.
the
same
roof
level as
line.
the
Yes,
roof.
yes.
right? That you make this roof the
Yes.
same as this, and then put a roof deck on it, you still get the extra room for the elevator, and you also get a lookout.
It's just, it's the access to it. We wouldn't.
You have to
The
stay.
difficulty is you'd be walking up another flight of stairs outside. And for safety, I'm not crazy about doing a lot of exterior stairs outside as we all age. But
Put a hatch.
you're actually, or a hatch, right?
Okay.
I've seen a hatch.
There is
Yeah.
a,
If you did it
Linkage
with a
would make me
railing,
crazy as an architect.
if you did that
And
with
an
a
engineer.
railing,
Yeah, and an engineer, of course.
you wouldn't have a room up there.
No, we would not have a
So
room
you'd
up.
have to give that up.
Yes, that's exactly correct.
there is a deck on top of the screen room. I don't know if you saw that. And the access to that deck was from that
Yeah.
room at the top of the tower.
Okay, so I'm going to give you your options so that you can decide how to proceed,
Okay,
okay? One, we can close the hearing and vote on it,
okay.
okay? If we vote on it, and obviously if we grant it, all fine and good, go ahead and build it, and you're, in good shape, unless somebody protests it, obviously.
Nobody protests.
If we deny it, you can't do anything for 2 years.
What? Oh, wait, we can't just,
You can't do anything for 2 years.
You can't submit
Submit an
a
application.
similar application.
You can't
You can
submit,
build your house without the
You
45
can
feet.
build a house.
you can,
Compliant.
right.
oh, okay, got it, never mind. I-
Right, you can't come
I thought-
back
I
to
thought we
us.
couldn't do anything.
No. As long as you meet the code, you don't come to us.
Right.
You can't come back to us for 2
Understood.
years with anything similar,
Right,
okay? You can withdraw without prejudice, which means you could reapply tomorrow if you.
okay,
You could ask for a continuance to change your plans. These are all of your options. Because there's nobody here, so opening it up to the public is already done. We're at the point of closing the hearing. If I close the hearing,
Right.
then we're going to vote on something. So again, this is something that you need to be aware of, is if we were to vote on this and vote it down, then
Then we
you couldn't
stay
build
within
anything
our-
similar to this. You would have to conform to all the building requirements,
we just do normal building
a
code.
normal building code.
Yeah, that's fine, and on the 9th edition.
Right.
But the frontage issue?
And the frontage issue,
That
finding.
we'll talk about, that's a different thing. We can vote on the finding. They're separate votes. They're totally separate issues.
That's
And
what I
I
was
think,
making sure.
I just want to make sure that we're not.
and I think it's appropriate to vote on the finding part of it, because it has nothing to do with the tower.
That's a good idea,
And no matter what you do, there's probably going to be that same issue.
yes.
So we can certainly vote on that part of it, I don't know, can we do that? Can we, if this has two aspects of it, can we vote on one and continue, and
And this is for you to decide, correct?
Well, the application was just for the variance for the height.
no,
I'm just a tool.
it actually showed both.
No. The,
So I think you
Says
could,
frontage requirement.
I think you could bifurcate it.
Excuse me?
I think you could, if you're here for two
Well,
separate
I'm
variances.
now,
Yeah, it was
For a
no,
variance for the frontage requirement and to increase the height, so there are two
Right.
parts. of
Yeah, and I think they could withdraw their application
Okay.
for the.
Or they
whatever
could
want.
continue, or.
Whatever, for
Okay.
the height, but I think you could vote on
Finding.
the finding for the frontage.
Okay, thank you.
Yeah, because they are separate,
They are-
they
they
were
are-
listed separately.
Yes, right. They're not linked in any way.
Yeah.
No, I know, they're gonna decide. I'm just, architect.
Well, you wouldn't get, if you withdraw, you can't go 5 feet. So if you move, if they decline it.
You can't go up
It's the same thing.
for 2 years, and then you're most likely looking at a 6 feet variance,
That's true, that's right.
if not
We're
more.
going to,
Right.
But there's going to be one issue, because of the change in the floodplain. If we decline this and you have to go back and reapply, then it's the new bylaw, then it becomes a,
If they turn in a new application, then it's the 10th edition.
right.
Yeah, so it will be a 6-foot variance that they'll be asking for,
Would that,
or more
Now,
if
if
it
they come in
changes.
and just said they want to make a modification, does it
They
still
make a
be?
modification. Right now, the way I understand it, they've applied.
Right, okay.
And Randy was here. Randy denied him on what he denied him on. If, myself, I would work with that. If they pull out, not doing, we're gonna regroup the application. You can't let that application go past 6 months. It becomes null and void.
Okay.
Then I need a letter from them saying, due to whatever, we need our application extended. If it's coming too close to the 6 months, I need them to send me that letter. So me as a commissioner, I can say, okay, I'm letting
do
you
this.
have extra time, because it's in here, to work with your application,
So,
to
so,
keep it under the knife.
so they would not
Ralph, tell me this.
necessarily have to
So-
go under the new rules.
That's right. That's what he's saying.
If they let it go.
Right, if they let it
without-
go.
If they let it go, it's gone.
But you're saying you could.
I could authorize it to be, but I need the letter, because if they're gonna go back to the planning board, the planning stages of it, and redo it and replan it, they need to submit me a letter.
okay.
Randy's letter is dated February 22nd.
But when, your
But you know,
application, when was that submitted to Randy?
February,
Before, yes, before that, I don't remember the specific date.
it
You
was
better
in
do it
February.
ASAP.
You're gonna do it ASAP.
It's gotta be done.
Yeah, so we have to immediately send you a
You
letter.
immediately send
that-
me-
Because it's gonna take a while to do new
You
plans.
immediately send me that letter and just
Thank you.
email.
Because if you get rid of the tower, you're still gonna have to get a variance of a foot, because everything's going up.
Right,
Everything's
right,
going
that's
up
it,
by
and gonna change all the stairs, huh?
3-foot buffer now.
Okay.
So how do you want to proceed?
So if we move forward with the vote and doesn't get approved, and then we change the design and keep everything at 40,
Then you don't come back to us.
right, and
As long as Ralph can get it in under the new,
And we
Right.
write
Write
Ralph
Ralph a
a
letter
letter
saying-
and said, please,
yeah.
But we could act on the frontage issue tonight.
yes, for
Right,
the
right.
finding.
and then you don't have to come back.
So let's act on both of them tonight. We'll-
Back to
Because
the
I don't
right.
want to delay this, because we're just going to get into further
Yep.
trouble with addition time.
Yep.
So
We-
I don't
No,
want
that's
Got to get the
perfectly-
design wrapped up. so-
Perfectly reasonable, because whether, if we,
If we can afford it.
it turns out to be the same, except like you said, it adds time. If we
Yes.
reject it, you change your plans, you submit it back to him as an amendment that meets the 40 feet, and you're golden. If you went back and changed your plans and come back to us, I mean, all that was doing was moving time out.
Right. I mean, if we bring it to 42, we try to but, I mean, yeah.
The longer this takes, the
We wanna move on.
longer I can't retire. So,
Ralph,
no, and
now-
I say that, but
now-
we're eager to.
Okay, I'm going to play devil's advocate, because I want to protect these people as much as I can.
Thank you,
Which we
appreciate it.
The, okay, so let's just say, and again, this is just what if. What if we reject it today, which means they cannot reapply for 2 years with with a similar design,
For the height.
For the
for the height.
variance.
And they come back to you, but they don't meet the 40 feet, they meet 41 feet. You're going to deny it, it's going to come back to us. But it can't come back to us because it's not
Right.
2 years,
Right.
Right, so you have to make sure you can do it in 40 feet.
Yeah, no, we can do
right?
that, yeah.
And you got to understand that because that's,
Right, right. No, we understand that.
Or you could withdraw your petition without prejudice for the,
And would it still do the frontage?
and they can still do the frontage, and then if you need to come back and, for your variance.
Right.
You're not prevented
Oh.
from coming back.
that's actually the cleanest way because that allows you then, if 2 weeks from now you decide you really want 41 feet and you think maybe we'll approve 41 feet because of whatever, then you could do that, you could do that tomorrow or next week. But you can't do that if we reject it.
Understood. Have you ever approved anything over 40 feet?
We haven't, we've never had any come above 40 feet that I can remember.
Wasn't
And we're
there
talking in the
somebody
sensitive
wanted
area,
to do
too.
it on the other side of town?
No,
We were warned of this.
Yeah.
What did he do?
It's actually more beneficial for everybody to withdraw that portion of it because it really protects both of us. It's the same of us. The only difference is if we vote to reject it, you can't do anything for 2 years. If you withdraw, then it's like you were never here.
But we want to know, are you going to vote for it or not?
That's,
It's like gambling.
and we're in Foxwoods right
So
now.
anyway,
Nice bunch.
excuse me?
What's the vote to pass the variance? What?
You have to have 4
Of the 5.
affirmative votes out of 5 in order to grant.
So let's take a poll. Let's see.
And just so you
That's the
know,
way this works.
the standard is specifically finding that owing to circumstances related to soil condition, shape,
Right.
topography of the land.
Land.
So the topography of the land is what we were using as the hardship.
That is different in kind, that especially affecting such land or structures, but not affecting generally the zoning district in which it is located.
Right.
It's a tough standard, very tough
We
standard.
understand. It's, again, you guys decide it's.
You guys.
All right. We'll withdraw it and just have the
I do.
finding for the frontage.
Okay, all right.
Okay.
And
So
send a letter to
you
Ralph.
write out a thing for him to sign and. So what you're going to do then is you're going to ask to withdraw without prejudice. Because that then allows you to come back anytime you want.
Okay, go for
We'll
it.
then vote on it and, but I have to close the hearing first to do, no, not for him to, he can,
You can ask now,
You can ask.
then you can close it.
then I close.
Yep.
And either way, it doesn't, we still write you a letter
You
ASAP.
still write me a letter because it sounds like it's real close. to
It's real
6
close. Yeah,
It is.
understood. All right.
I have a question. Should you put on there as it pertains to the height variance for the
Yep.
height requirement?
Yes.
Yep.
Because you're-
Yep.
Yes.
I should put that on here?
Yeah, regarding the height variance or request for a height variance.
That way we can still act on the frontage tonight.
Spell that wrong.
Good?
All right, so I just read this and we're good? I, Glenn Ellis, petitioner, request to withdraw the petition regarding the height variance of property located 12 Old John Reed Road, currently pending before the zoning board of appeals without prejudice. Signed, Glenn Ellis. date
Signed and dated.
7/9.
Sign and date it? Okay, is there any other discussion before we close the hearing? No? I'll entertain a motion to close the
Make
hearing.
a motion to close the hearing.
I second it.
All in favor, say aye.
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 Aye, all opposed, no. It's unanimous. Okay, we have a request to withdraw the variance on the, in particular for the height. Any Discussion.
I move that the applicant be allowed to withdraw the height variance request without prejudice.
I'll second that.
Any discussion? No? All in favor, say aye.
Aye.
Aye. All opposed, no. That's granted. There's a second is a finding that that the requirement for the frontage, okay, which, oh, here it is, right here. That the requirement for the frontage, which is required to be 100 feet, according, is actually 94 feet. And the finding is that there has been a house on that property. So it's been a non-conforming property. It hasn't changed. It doesn't affect the neighborhood. And as far as how it's detrimental, what we use for that is not that it's, the architecture is detrimental. It's safety and things like that. It's something tangible. And I don't see that there's any impact of the 94-foot versus the 100-foot, especially since it's already deeded at 100-foot, and the town has identified it on their card as being 100-foot. So I make a motion to grant a finding that the 94-foot frontage does not impact is not detrimental to the neighborhood.
I'll second that.
Discussion? All in favor, say aye.
Aye.
Aye, all opposed, no. So now you don't have to worry about the frontage. You can take care of, you can take, with Ralph, you can take care of how you're gonna manage the height.
5 feet.
Jeff, do we have to put the word substantially in there?
Yeah, you can, substantially more detrimental.
More, it's not more detrimental, but yeah.
More detrimental, I mean, I think the,
That's right, that's good.
yeah,
That's what the rules.
It's a 20-day, don't do anything for 20 days because it's a 20-day appeal process.
Okay.
You can still work with him, but
You could,
Yeah, yeah, yeah.
don't go building
I
stuff
just
for 20
don't
days.
issue it until I get,
Got it.
I would submit it sooner than later, and it's online now. I don't handwrite permits anymore.
Oh,
Hit buttons,
you're on that new system, right?
yeah.
All right.
Okay, thank you.
Thank you very much.
Thank you for your time.
Thank you, we appreciate your time.
Thank you.
Thank you.
Looking
I
forward
hope
to
it all
being
works,
around
I hope it all works out for you.
I'm sure it
It
will.
will.
Okay,
No, he's on he doesn't do permit.
order of
Oh,
business.
you mean applying for this? Oh,
Chairman, I just need
applying for other stuff. I don't know.
Yep.
Okay.
I wanted to see if I could make it 20.
Sure.
Did you go to Lake Eaton way down?
Not tomorrow, because I gotta do CI inspections, come see me Friday morning.
I wish I would've known that, I would've, or I would've come early.
Come right at 8 o'clock, Phil. Yeah, no, I live,
Yeah,
8:30.
I get in at
Shoved in that other big stack of shit that we have.
I know. I went to look in there, but I didn't.
curious to see.
You have a
Alrighty.
Hey, if that's where you get.
That one opens up a huge can of worms. But
Oh, no.
It's
It's a mess.
Yes, yes, right, yeah.
I don't play around in a chair because in the home office, I just have a stationary chair.
No, right.
Lots of rules here. You work pretty good.
No, you did
I
3,800 yards this year.
I worked from home since COVID and I retired in May, so.
How you been getting along?
great.
Good. You still don't feel any, you still, I know,
I got something going on. I got a gig going on.
Oh, but you're not, so you're not.
But I'm technically retired. I am technically retired, baby. I am unemployed. I have no income. Nothing. How old are you?
We're still running.
61.
We're still running a meeting.
What?
Okay. Next order of business is meeting
What's that
minutes.
about?
And I'll see you running the meeting.
No.
Okay, we have meeting minutes from May 21st. Everybody's looked at this, remember we put this together, everybody's commented on it. So I'll make a motion to approve the meeting minutes for May 21st, 2025.
I'll second.
All in favor, say aye.
Aye.
Aye. Opposed, no. I'll sign this. Is there any other business? Our next meeting is,
July 30th.
Woohoo! Oh, I make a motion to adjourn the meeting?
all in favor? Aye. Aye. Opposed, no. Okay.